founder and CEO of Riverus. Riverus is a legal technology company. You could say that in some sense we have been we have been able to foresee that our legal system will undergo large-scale changes, including which will require intervention through technological means. So three years back, we started building what you could call a legal analytics system for income tax law for India, and we are very proud to say that we are probably the only company in India which has a robust database of analytics for tax courts, tax judges, and the way that they sort of determine matters from time to time. And I think all of that could be quite useful as we move from a very face-oriented system to a very faceless system. But more on that later. I would now take this opportunity to introduce our esteemed panelists. Today we are joined by a person, a stalwart from the bar, a stalwart from the consulting world, and a very, very experienced in-house tax counsel, so that we are able to get you views from all sides of this table. So we have today with us Advocate Mr. K. Gopal, who happens to be a very, very well-known and experienced tax practitioner. He's also the Vice President of the ITAT bar, and he regularly appears for assessees before the ITAT, High Court, and also the Supreme Court. Mr. K. Gopal, sir, welcome to the Riverus webinar.
Good evening, everyone.
I also have with me, and very, very fortunate to have Sunil Badala, who happens to be the leader of the financial services practice for KPMG. Sunil's presence will help us to understand how the industry and the largest of the companies which consult KPMG are actually viewing these changes. And Sunil will bring some very unique perspectives onto this table. I'm very grateful that Sunil could take out time and attend this webinar in person. Thank you, Sunil. Very great to have you here.
Thank you. Pleasure.
Thank you, Sunil. And I also have, last but not the least, and someone who probably really at the heart of this webinar is Keshav Loyalka. Keshav is an experienced tax counsel who has worked in many organizations, but I think very closely followed how tax provisions have impacted the industry. He's someone who has probably gone through the pains of the tax system and its procedures. And not only that, he's worked with large multinational and domestic financial services companies, so seen very closely the impact of taxation provisions on those organizations. So we're very fortunate that Keshav is here, and he will talk to all of us about how he perceives the provisions of Budget 2021 so far as they relate to assessment and appeal procedures. Keshav, welcome to the webinar. So with that introduction, I would basically kick off. Alicia, if you could bring us to the first slide of the presentation. So this presentation will basically be a guiding factor for us as we progress through the webinar. You could look at this presentation to see what we are talking about and where the discussion is going. As all of you know, that the Finance Bill 2021 is now on the table of the Lok Sabha, and they will be considering the Finance Bill, and it will be passed in due course. There are many new provisions so far as the assessment procedure and the appellate procedure is concerned that have been introduced in the Finance Bill. The provisions have been introduced to basically address some of the inefficiencies as the government would like to put it. However, those provisions are worded very broadly, and I think the view that that emerged from the practitioners community and the taxpayers community, that although well intended, the devil really lies in the details, and how the provisions are actually executed will show whether they are working as per the intention of the legislators, or they're taking us somewhere else. And sometimes these provisions have also have created concepts like faceless appeals, which some of us find it difficult to reconcile with, given the fact that we are used to being able to address the court in a particular manner, and if we do not have the opportunity to address especially courts like tribunals, which determines questions of fact through in-person hearing, there is a feeling today that this could take away some of the rights that the assessees have, very important rights. So I think to discuss all sides of these proposals, we will kick off. And in order to kick off, we would first go to the practitioners, the consultant, and the industry expert with very quick views, a couple of minutes perhaps, on how they perceive the finance bill, and then we go from there to the slide one. So to Sunil first. Sunil, would you kick off the discussion and give your quick reaction on what you think has changed and how you perceive the Finance Bill 2021?
Sure, Dipankar, and thank you so much for the kind introduction, and I think a very nice background to the whole discussion. Good afternoon, everyone. It's my pleasure to be part of this discussion. So, just few quick comments. I think to your point, Dipankar. I think this budget has to be actually looked at in the context of very unprecedented times that we've seen. As you all know that globally the economy has contracted. There was a loss to the life, to the business, and in that background, obviously everybody was expecting some harsh measures to be taken. People were talking about, let's say, new levy of taxes. There was a lot of talks around a new COVID cess coming into picture. Obviously there was the economy was struggling. We've seen a contraction of more than 7.5% in the GDP of the year 2021. But of course, not to forget overall shortfall in the collection of taxes, not just when you compare with the budget, but also with the collection that we as a country have made in the last year. So I think in that backdrop, if you look at this budget, I would say it's been a very progressive, very investment oriented budget. Also, I think they've at a macro level focused on the right things. So there's a lot of focus on healthcare, a lot of focus on infrastructure, and focus on the financial service sector, etc. They've been very significant and remarkable regulatory announcements, and we have to see each one of those as to how they will pan out, how government will implement. But a lot of interesting regulatory announcements. So again, without getting into too much of details, I would say, most of them were the new powers. And last but not the least, I think, Dipankar, you've already briefly touched upon, and I'm sure we will discuss this in greater details, some very, very significant changes which have been made, and some of them are really, really path-breaking. So, if you ask me from a policy direction perspective, I think it's a good budget. But let's see how each of these get implemented, and also, as you correctly mentioned, the devil is in the details. So let's just go through some of those. But at a macro level, I will say a very progressive budget, and needless to say that the market has reacted very, very positively. In last few years, or let's say couple of decades, I have never seen market actually embracing the budget so much as it has been embraced by the market now. So it's already 10% plus up. So that, I think, is a good news. Maybe I'll just stop here and invite reaction from my other panel members.
Mr. Gopal, would you thank you, Sunil. I mean, this is a very positive note to kick off. Mr. Gopal, your quick reaction on the budget, please.
Yes. Dipankar, thank you very much for nice words. Yes, I have been in the profession, and according to me, this was a really path-breaking budget. Earlier, we were expecting in 1997. Many people have mentioned in the what kind of budget was presented at that point of time. Similar kind of path-breaking budget in this, especially trying times. But I will limit myself into the other general aspects. There are so many people, economic, their experts are there. They have given a very thumbs up to the budget. But there are certain aspects which are I would like to, when taxation comes, especially when we get into the details. Some points I find as an advocate I'm not able to digest. They are trying to tinker with certain provisions, and still they say that we have done away with retrospective taxation. I will just point out they wanted to rope in. There was an issue with respect to the employees' contribution to the PPF or Provident Fund, which was being disallowed, but if paid within due date 139(1). One court took a view in favor of the department, other courts took in view in favor of the SSC. Now they are bringing it, making it taxable, or reversing the decisions by bringing a retrospective amendment. Again, it puts you back into the same regime. So after saying so many things, why do you want to tinker with the court decisions? Accept it or leave it. Let the law develop, because these things will keep on happening. How many decisions you are going to tinker in this manner? Because you have got a legacy of disputes. What to do? The statute was administered in that manner. So that's it. That's one part. Now, a positive side is they have tried to bring finality to the assessments, or they want much more clarity and transparency in the system. Very good. But as Dipankar said, the devil lies in the detail. So when we proceed further, then we will find out so many other details which will say that yes, the intentions are good, but what in detail what they are trying to do, they're putting us or the SSCs at the mercy of the bureaucrats. It's not a very happy situation. Tax gatherers have got their own way of dealing with things, which I don't think so. It's a very the process of creating checks and balances is not balanced now. I leave it at that. Dipankar, you can ask Mr. Keshav to give his comments.
Thank you, Mr. Gopal. Keshav, why don't you put your perspective and give quick reaction to the budget?
Yeah, thank you. First of all, Dipankar, taking cue from my other panelists. First of all, this budget is really a right step in the right direction. Primarily, as per our vision of our Prime Minister to make our country a 5 trillion economy, I think there are structural changes being proposed. The intent is clearly to facilitate foreign investment and to give tax certainty. And I always believe that budget, there is always so much hue and cry on a particular date. Uh, and my take is that it should be a little non-event. The policy making cannot happen on a particular day. It should be a continuous process, and that's where I have been seeing, in my knowledge, Prime Minister of a country, our country, comes on national TV on 12th of August, just 3 days before he is going to address the nation anyway as a part of independence celebration, and talks about a project called Honoring the Honest, which is basically a launch of faceless assessment as well as adopting citizen charter. So there are very positive steps taken in right direction. On the budget front, Finance Minister, Honorable Finance Minister has chosen the path of giving stimulus to economy by supporting demand and by injecting money. Uh, we have accepted a huge deficit of 9.5%, but the key is that we want the economy to revive faster. And if I have to take a cue from the GST data, while there was, because of the global pandemic, the first 3 months of the lockdown have been a really a negative growth of 23%. But if I look at from October 2020 onwards, we are looking at a GST collection at a national level of 1 lakh crore plus, and the December being the record high GST collection of 1.15 lakh crore, which clearly reflects is basically on the background of the festive season demand as well as the pent up demand. So as we see, India as a great domestic market, Indian stock market, needless to say, that is giving a resounding thumbs up to this budget. Not only the budget, the entire potential of Indian economy in terms of growth. And I think India is one of the few countries which has got net FII investment during this pandemic driven year. So I see there is a very positive aspect in the entire budget. But yeah, there are certain provisions where the intent is clearly to provide tax certainty and give investor a confidence to invest in the economy. But certain nuances needs to be addressed, and which we will deal as we go ahead.
Keshav, thank you. Very valuable remarks. So now we now get into really the meat of this webinar. We now get into the actually looking what kind of details have been provided. And I think for that we have three segments. The first segment deals with, giving an overview of the tax procedures which have changed, and also looking at the the new concepts that have come with respect to reassessments. Sunil and Mr. Gopal will take that, and Keshav will bring his perspective as well. Then we have faceless ITAT, and all that will change with that, and we will have Mr. Gopal taking the lead on that, and Sunil and Keshav putting their rejoinders there. And finally, we will hear from from Keshav on the Board of Advanced Ruling, the new concept that has been introduced, or the old concept which has been repackaged. He will give his perspective and some of the other key changes. So these three segments are coming up. Now with the first segment, Sunil, maybe I can request you to kick off this with giving some understanding of the overview of the tax changes, and also take up the assessment, reassessment related changes. Thank you.
Sure. Okay, so if you just stick to the slide number 2, which is on the screen, and I hope everyone can see that. I think the first bullet point, I think Keshav has already dwelled into that. Obviously the government's resolve to simplify tax administration or ease of compliance or reduce the litigation is very much stated time and again. Whether it was a faceless assessment, appeals, the dispute resolution panel, VSV, and many other policy announcements that have been made so far or are being made in this budget. Obviously, we're not getting into the details around how effective or otherwise they are, but yes, that the intent of the government has been clearly stated time and again. We are seeing an increased use of advanced technology at the government's end, and I'm sure all of you have actually experienced that. There's a lot of artificial intelligence, a lot of statements of financial transactions, etc., are being referred to by the revenue officers. The recent change, as you all would have noticed, the revision in the form 26AS, where they started including GST data analysis. They started putting up all the financial transactions, etc. So it just goes to show how government is actually getting absolutely hands-on to all this data, and how effectively they are trying to make use of these data, etc. So the big data analytics seems to be clearly the path to go as far as the government is concerned, which again I think explains the position that yes, we are seeing more digitization in taxation procedures, uh, and again, in terms of the government's intent to reduce the litigation disputes with the taxpayers, Vivad Se Vishwas was one scheme which is still currently going on, and a lot of disputes have been actually settled between the government and the taxpayers. Uh, Introduction of faceless assessments and appeals I have already spoken about. So this is the backdrop of some of the procedural changes that we've seen in the budget, and is the main theme of this session. So we will discuss some of these details as we go along. So Alicia, if I may request you to change it to the next slide. So
Sunil, just to add on this, uh, if you may.
Sure. Yeah, absolutely. Keshav, go ahead.
I would like to say share a few pointers which I picked up from the economic survey, and it clearly reflects that the government is very much keen in terms of addressing what are the areas where there is a reform is required. First time I can read in the economic survey, the government has accepted that uh, ease of doing business is one of the important criteria, and one of the subset of that is ease of closure of the business. And in the economic survey, there has been a very clear category admission that we are dealing with as a country, as an economy, we are dealing with a problem of over regulation. As Gopal said, that the bureaucratic mindset, but government economic survey clearly says that for winding down a company in India, you on an average take 4.5 years, whereas in case of a Singapore or other European countries, it is 12 to 24 months. So this is a very important admission, and in line with that, again the government is saying, and the data suggests that we simply go, there is no accountability. Somebody wants to appeal, he just want to appeal whether checking, without checking whether we are getting any outcome of those appeals. And again, picking up from the economic survey, it shows that around 87% or roughly 85% cases the department goes into appeal, and the success rate in that, or they lose almost 73% in Supreme Court, 88% in High Court, and roughly 73% again in the tribunal. So clearly there is a need to introspect that what is government achieving out of this enormous litigation. And in that backdrop, the government is clearly trying to find out things which can expedite litigation and provide tax certainty to the taxpayers. And the intent is at least very clear. Direction is being analyzed, supported by data.
Sure, I think very well said, Keshav. So, yes, so one of the main changes that this budget has proposed is in the procedure of whole reassessment. So as you all know, currently the assessing officer has powers to actually reopen the assessment for 6 years from the end of the assessment year. Now that period has been proposed to be revised down to 3 years from the end of the relevant assessment year. And the whole idea obviously is that government recognizes the fact, as Keshav said, that there needs to be a speedy resolution to the disputes and appeals, etc. And obviously the assessment and reassessment are the probably first or second steps in that direction, and therefore the time limit needs to be reduced. Also, government is now sitting with lot of data. There are a lot of exchange of information happening amongst the different regulators, and therefore I think the government can afford to reduce the time limit of 6 years to 3 years very easily. So that is what has been proposed. In some specific cases, the time limit of 3 years will actually go up to 10 years, provided the income which has escaped the assessment is in excess of rupees 50 lakhs and is represented in the form of assets. So we will actually look at some of those details later on. But although the finance minister in her speech very clearly said that this time limit of 10 years will apply to only specific serious tax evasion cases, but we have little bit of concern in terms of the way the language has been worded, and it can actually lead to some kind of a subjectivity and therefore again litigation with the tax officers, because the only thing what it says is that if there is an income escaping assessment in excess of 50 lakh rupees which is represented by an asset, then the time limit goes up from 3 years to 10 years. I would like to believe that the intent is to actually only cover specific tax evasion cases or search or seizure type of cases. But as I said, there is a little bit of concern in the way language has been drafted. They've specified, earlier we had the criteria of selection of reassessment as reason to believe by the assessing officer. They've now made it more objective to say that okay, there has to be something concrete with the tax officer and he has to share those information with the taxpayer. So let's say if there's a CNAG, controller and auditor general objections, there are some flagged cases based on certain risk parameters which have been set out in the system of the department. Search and survey cases I've already talked about, and so I think those are the specific cases they are actually trying to bring onto the table. So the way it will happen is that under the new procedure, the assessing officer will actually have to provide opportunity of being heard right at the beginning when they issue the reassessment notice. So they will provide the relevant informations which has come into their possession, and they'll ask taxpayers to actually give their views in terms of assessing taxpayers' perspective on those relevant information. Of course, there is a proviso, there's a carve out to say that the search and requisition cases will actually be deemed escapement cases, so that they may not provide an opportunity before they kind of before they initiate the reassessment proceedings. But of course, needless to say that having issued reassessment notice in the assessment process, obviously the adequate opportunities will be given, but right at the issuing of the reassessment notice, they will probably not give the opportunity of being heard. There's also some checks and balances proposed to be put up, which is that before they issue the reassessment notice, they will have to take specific approval of either the principal CIT or the CCIT, depending upon the threshold of the income being escaping assessment that we are talking about. So that is the framework which is being proposed to put up, and maybe I'll invite Mr. Gopal's comment on this before I move on to the next slide.
Thank you, Sunil. I think as a in a very lucid and detailed manner. You have explained all the provisions, what are in operation, what is being proposed, and I think I will do what advocates are notorious to do. I will just give the critical points and what is the see, they are suggesting, as Sunil said, they have got putting intentions, but whether they are translating into the statute book, they are putting it there. Let us examine them. Now, see, what they want to do say is we want to create an atmosphere where ease to do business is there. If ease to do business is there, then somebody gets away, gets away. We, leave it at that. No, they want to see to it that yes, he can retain also certain powers, and we would keep on saying that assessments have reached finality. So, but these provisions which they are proposing bring certain finality with respect to certain issues. As Sunil has mentioned, the earlier provision, now the present position, they give 4 years, time period for where 143 scrutiny assessments have taken place, 6 years in general, or any other, reason to escape, or so many conditions are there. So they used to lead to, I usually say that these 147 were their paradise for advocates, because so many writ petitions and all we have been filing and succeeding also. Now, by changing this, what they have done, they have put 3 years, it's final. If beyond that, if you want to reopen, then you have to have a material. So all those change of opinion, income, any failure on the part of the assessee to make a true and full disclosure, all those things are over. That won't be there. But the way they are going to come up with this 10 years and all, it seems that the way how they want to proceed, they are creating a procedure again, and then once you create a new procedure, then it will have a new challenges, and there can be new challenges before the courts also. What I thought simply they could have done, you keep all reopening at 3 years, don't touch anything, let the assessment reach finality. Anyway, you have got 153 capital A and you have got 153C. You continue with that. There, search and seizure takes place. You go and do for 6 years, 7 years, 8 years, because you have got it clear. In both the matters, wherever you find, we will cover them. But you want to have, put all those things over here. So it will again create an issue for 10 years. The block assessment concept, those things will come multiple number of, because this concept was there prior to 1995. And again, all those search and seizure assessments, and because definitely when economy will grow, these kind of these issues will come about the taxation, evasion, and all these things will be there. You have to be prepared for that. Now you can't say that because of ease of business, we will not. Our officers won't be vigilant. Or if they are going to be vigilant, they are going to be so stringent that it will going to affect the life of the honest and general assessees. So that balance, unless and until they rein in their officers, this is going to continue. And let us see the new provisions. They have differently worded it. The challenges may go down, but still certain things are still open, because the concrete material, again the issue will come, what is the concrete material? Though there are certain case laws which say what is a tangible material and all. So according to me, litigation will go down to a certain extent, but it may open up certain new challenges.
Thank you, Mr. Gopal.
Sorry, Sunil. I think litigation possibly may not reduce, because this opportunity to give to assessee before it is passing an order, whether that order is appealable or if not, you can straight away move a writ challenging that the reopening is not in line with the provisions. Again,
Keshav, I agree with you. That's the reason I said they are laying down a new procedure.
Correct.
A new procedure, what will happen? The natural justice point will always be there.
Yes.
As we proceed about AR also, I will, when we discuss that, I will tell about, because again, when you try to create a new procedure, then again there will be new challenges will be there. So where legislature has, statutory provisions are there, there is a code developed law is there, and it has reached to a certain level. According to me, you should have done something to reach that finality, so that in those parameters, your
I mean, Mr. Gopal,
statutory
we are losing.
provisions are operational, and you are able to proceed with that.
No, I'm just saying the silver lining is still ahead, Mr.
Okay, okay. Thank you. Hmm. We can go to the next.
Yeah, no, I think I mean, those are very good insight. Mr. Gopal, I won't call this as a notorious act of a lawyer. I think it was very kind of you to actually pass on all the difficult and relevant messages. So okay, with that, let me just move on to the next one. So we've got now proposed dispute resolution committee, which will essentially take care of small taxpayers. Basically, what we are saying is, if let's say your return income is less than 50 lakh rupees, and the aggregate amount of disputes or adjustments that the tax officer is proposing is less than rupees 1 lakh, 10 lakh, 1 million, then those taxpayers are actually eligible to apply to dispute resolution committee. We have yet to see what kind of framework will be put in place. So obviously, as a concept, this looks like a good concept for the small and medium sized taxpayers. But again, if it's going to work like DRP or some of the other initiatives taken in past, then again there may be some concerns, or rather big concerns in terms of implementation. But as a concept, I think it's a good concept for resolving the disputes for the small and medium sized taxpayers. Obviously, there are some clarifications to say that search and survey type of cases will not be eligible. uh, the CBDT will come up with some additional conditions, not only additional condition but also the overall framework around this. Uh, Amongst other things, of course, DRC will have powers to kind of waive the penalties, or or provide immunity from the prosecutions to the taxpayers. Like they've done for assessments, appeals, and now for the tribunal, they are also proposing that there could be a faceless system with dynamic jurisdictions for the DRC. So, like for example, a taxpayer sitting in Mumbai may have to deal with a DRC sitting in, let's say, Delhi, and so on. So, I think that's all as far as this slide is concerned. Maybe we can move to the next one, Alicia.
Right. Sunil, thank you very, very much. And both you and Mr. Gopal brought uh, very interesting topics. I think we'll have some interesting questions to ask all of you at the Q&A. But now we move to the next interesting chapter of presentation, where we talk about the faceless ITAT. Now, of course, we have seen faceless appeals and faceless assessments, and there are thoughts about how they are working, whether they're working efficiently or otherwise. But I think government is keen now to have the major and the first tribunal, if you like, to go into the faceless mode. This is, if you whether you like it or otherwise, this is very transformational kind of a step, because it goes against, or it goes in a very different way that the judicial process has worked so far. I- I- We had a very interesting discussion prior to this webinar, and I would request Mr. Gopal to maybe take the lead and give us his views as to how this is going to work. What should the litigants expect, and where are the pitfalls, and then we will get Sunil and Keshav to also chime in on this particular issue. So, Mr. Gopal, you please give your views on this. faceless
Yes.
ITAT?
So, uh, uh, thanks, Dipankar. Uh, Income Tax Appellate Tribunal, ITAT. See, I have got a very my practice, entire practice before ITAT, High Court and Supreme Court there, but ITAT is something I have been devoted a lot of time. So ITAT is some nostalgic moments I will share with you, because in 1996 as a junior when I was in practice, so there was a one challenge where ministry law secretary wanted to take over the rights of transferring the members of the ITAT. At that time, that was challenged. I was the advocate on record at that point of time. And while after filing that writ petition, the most important, the best thing in my life happened. I had an occasion to brief the legendary jurist Nani Falkiwala and spend time with him and argue with him in the court. And that was something so this ITAT gave me that opportunity when I was appearing for that. Now, ITAT, how it came into existence, because in 1941, earlier, prior to that, there was no provision for an appeal against the, which was beyond the income tax department. So, after the commissioner or IAC, all the matters used to go to High Court. They found it very difficult how to handle this. So, declutter High Court jurisdiction so that people can seek their appeal. So they created a body within the Income Tax Act, but which has got the superintending ministry beyond Finance Ministry, that is Income Tax Appellate Tribunal, lies with the Law Ministry. The entire procedure and everything, it is like a court, but it is not a civil court. So it has got all the trappings of the court, but it doesn't have the deficiencies of the civil procedure code to slow down the process. So ITAT functioned very well. ITAT, has it is a mother tribunal. It is called because after, on the basis of the success of this tribunal, so many other tribunals were created. So while the challenge I mentioned about when the matter went to Supreme Court, there they observed that the court, tribunal is a court, and proceedings before it are judicial proceedings, are quasi-judicial proceedings, and any contempt to any act done in contempt to tribunal is a contempt, criminal contempt in the conduct as a doing something in contempt of a court. So that was the Supreme Court's view. Now, why I am giving this background is under Income Tax Act, the final fact-finding authority is Income Tax Appellate Tribunal. Now, the final fact-finding authority will be a faceless and having a dynamic jurisdiction. You won't know who is going to hear your matter, dispose of your matter, and it will be a proceedings. For that, see, technology is there. Definitely, you have to adopt yourself to technology. You should always make it more transparent. You have to make it more efficient. I agree with all these things. But faceless is not a solution at this level. See, what is good for a procedure for 10th standard or 12th junior college or for graduation, you can't say that at the post-graduation level and PhD level, you will have the same way of evaluating and holding examinations. How can you do that? That is not correct. See here, what happens once you go to a court, that court gives you a confidence ki who are the people manning that court. And it has not happened. Tribunal has let down the SSCs or the government or the department in this manner. So making it faceless, I don't think is a requirement. If you want to bring it, take the aid of technology to make it more efficient for faster disposal, I think that should be done. Faceless, I don't think so. What they intend to achieve, I am not able to understand. Because what is true for assessment can't be true for quasi-judicial proceedings, especially before tribunal. And recently, that is in the November 2020, there is a Supreme Court decision in the case of Madras Bar Association of the Union of India, where they have set up a separate committee to monitor and look into the proceedings, how it is to be organized at the Income Tax Appellate Tribunal. Then all of a sudden you come up with this scheme. I think they should take the views of we professionals also, and we will be in a position to tell them how to improve the situation, working of the Income Tax Appellate Tribunal. And one thing is very important during the pandemic also. Only in the month of April, May, and June, Tribunal was not functioning. July onwards, on virtual platform, it had been working, and it has disposed of many matters using taking the aid of technology. So, faceless, I don't think so is a solution. And let us see, they have kept it because they are going to notify it. But and there is a view saying that is it going to be a thing which is going to adversely affect the advocates? I don't think so. It is going to affect the advocates. I think that should not be the consideration when they raise the bar monetary limit for carrying out audits. They should not bother whether it is going to affect the professionals. What they should bother is at the first place, why did you brought it? Why did you bring it? You brought it because you wanted to take the aid of the professionals for easing out your life. See, right from the beginning, I will say 1989, Raja Chelaya Committee's report, earlier to that, 87 or 88, Raja Chelaya's committee report came. In that, first time they mentioned how to fix the accountability of the officers. Till today, they are not able to do it. Unless and until you fix your house, you put your house into order, this accountability is brought to the officers. This won't happen. You make it faceless or without faceless. What they will do, they will not take any responsibility. They will pass on the work to others. Then all these things will get clogged in the High Court because SSC needs a relief. One thing I will say, the earlier position dealing with Mr. Sunil and Keshav mentioned about the DRC provisions. Definitely, that will make the life of the smaller SSCs, at peace. Many people can go and settle it. But litigation, you just think 10 lakhs is nothing. 10 lakhs is nothing. Usually, now you find any addition is more around 30 lakhs or 40 lakhs or 50 lakhs. They all are going to again come in appeal. Then for that, faceless is a solution for assessment, even for CIT appeals and ITAT. I don't think so faceless is a solution.
Thank you, Mr. Gopal.
Yes. Sorry, you can,
for very, very interesting views there. And faceless is not the solution at the ITAT stage. That's the message that comes out from your point. Keshav, would you now like to come in and give your views and also take us through the last part of the presentation where the advanced ruling authority for advanced ruling is going to be changed to a different entity. Keshav, over to you.
Yeah, thank you. Primarily, I think faceless has become the flavor of the day, and I hear that this is one of the favorite topics of our honorable Prime Minister. So there is the thrust is from the top. But as Mr. Gopal explained, I am slightly worried that faceless regime should not be mindlessly applied. That's where there is a disconnect. Faceless scheme and dynamic jurisdiction is clearly a great saving for a small taxpayer who need not look forward to who is his AO. There are a small dispute. It can really help expedite those smaller litigations. But where there are large stakes involved, complex legal issues involved, we are going through the first round of faceless assessment and first orders are yet to come. How the entire scheme will pan out is yet to be seen. So possibly the better way is to go through one or two cycles of this faceless assessment, and taking learnings from them we can expand. If we are talking about using more technology, virtual hearings, e-hearings, those can be used from in improving the efficiency perspective. Otherwise, there would be a significant jurisprudence challenge. We talk about the jurisdictional tribunal ruling, which is in a way binding on the bench as well as on the taxpayer. But in case of a dynamic jurisdiction, how does it operate? So we are just deviating from the settled principles of legal interpretation. So effectively, this is, I think, a little too early a shot to take. Only saving grace, I see that they have notified it to be implemented by 2023, and all the notification in this respect will not be just by CBDT, will be placed in the floor of the parliament. So there is a greater scrutiny will happen before those gets implemented. Now moving on to the constitution of this new board of advanced ruling. At the outset, when I look at the provisions, a memorandum explaining this change, I am a little confused that whether this change was needed, because the problem statement cited in the earlier authority of advance ruling is the inadequacy of the members of adequate experience and leading to pendency that could have been simply, in my view, ramped up by increasing those bench capacity, providing the adequate infrastructure. Now, there is a significant change which has happened by abolishing the authority of advance ruling, which in a way I would say challenges the very fundamental for which an advance ruling one would opt for. So the premise on which a taxpayer suppose wants to set up a business in India, and there have been a lot of apprehension as through the Indian tax system is complex. So that's where it was brought in as a early redressal mechanism where one can go to advance ruling and determine the tax position in that. And in one of the critical aspect to that was that it was not a appealable order. So one could get a real certainty, and tax certainty is certainly a important canon of doing business. One would know what would be his tax cost, and accordingly he can price his products. But now with these all proposed changes, where the advance ruling authority has been abolished and a new board of advance ruling, and if we acronym it, it becomes BAR, which will consist of member not below the rank of chief commissioners. All the existing cases will be transferred, and the biggest change which happens is that it becomes appealable. Now with these kind of changes, we really need to see how effective this kind of board will be. Again, here also the intent is that it would also move to faceless regime, which may possibly be good from a non-resident perspective. But again, as Mr. Gopal argued, when we are dealing with complex legal issues involving complex transaction, there is an art of advocacy, there is a representation, everything cannot happen uh, 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 on a just a written submission. So with this change, I don't know whether this bar will be raised or it is just a new wine in old bottle. This is purely on a lighter note, but as things unfold, we will see how it goes.
Keshav, with your permission, may I add to something to this?
Yes, sure, sir. Most welcome.
See, in the advance ruling, see, when they are abolishing it, then they should have given this jurisdiction of advance ruling, created a procedure before the income tax appellate tribunal itself. Because day in, day out, you are there. And it would have a much faster way of coming to a conclusion. And because ultimately those very assessees, if the same issue they dispute post-assessment, those very issues land up before the tribunal. Then prior to assessment also, if they are, you allow them to go there, it will be much easier, duly binding also. You got an entire jurisprudence is there. Why you create, when they create AAR also, then this view was there you are creating, and they what they did, they brought a retired Supreme Court judge, and proceedings were not moving over there. Why they have to abolish it? Because it was not successful. Now they could have, done in this manner. It would have given ease to do business also. In spite of, instead of that, they created another, board where again chief commissioner is going to be there. How it is going to make a difference when you are going, you got all your internal departmental officers. For such kind of things at such higher level, you need a fresh perspective from both sides. The bureaucrats should learn to trust professionals. Professionals, when we sit and give talk in this kind of webinars, or whenever we give a representation to the government, we give dispassionately. We are neither in favor of the department, we are not in favor of the SSCs. We give what is a more, appropriate thing to for having a seamless tax gathering system. Unless and until they do that, this thing will continue, and again back and forth, so many organizations, and ultimately the net result will be they are not able to achieve what they are proposing to do. That's it. Anything else is there? Dipankar can take over.
Thank you, Keshav, and thank you, Mr. Gopal. Those are very enlightening views. I think we are coming towards the conclusion of the at least this round of the webinar. But before that, Keshav, would you want to quickly, take us through the changes that have come on the procedural side, which is now on the slide?
Yeah, sure, Dipankar. Conscious of time, I will quickly run through. Primarily, first thing is that it is just like a lockdown. The settlement commission ceases to exist with effect from the budget announcement. That is a quite a knee-jerk thing to happen, but I don't know. There would be certain thought process behind that. As regard other provisions, particularly with respect to assessment, those are welcome statement in the sense that those prepone the time limits for assessment by a few months. Now the time limit for filing revised return has also been reduced by only 3 months, reduced to only 3 months. That's where I feel is not a very good step, because there may be cases where a person has a genuine issue with regard to which comes to notice say little later in the part of the time, and then he loses the opportunity to revise return. Yeah, however, the time limits, crunching of time limit for assessment is a step in right direction, because it gives you a certainty of your tax position at a quicker time space. If we may just go to the next slide, where we have tried to capture uh, different dates. So these will possibly, Dipankar, you will be providing these slides. So these are just
We
for.
will. We will.
So if we take budget proposal, now it is actually 9 months. So the AO has to pass an order where there is no TPO reference by December 2022, which is a very good positive time frame.
Right, Keshav. So yes, of course, all the participants will receive a uh, copy of the presentation, and credit entirely goes to Sunil and Keshav for putting this together. But now, in the interest of time, maybe I could see if there are a few questions that we can get from our audience. If anybody has a question, they could raise their hand by clicking the icon, and we would go around and ask the question. We have 5 minutes to take any questions for our guests. Well, until such a question comes up, maybe I see no hand raised so far, but maybe I can go and ask Sunil and Keshav a couple of questions, and also Mr. Gopal. So maybe one question each. So on the first part, Sunil, which you dealt with, which is the new process of reassessment, and with Mr. Gopal dealt with that, there is a lot of things that can also create litigation. Is there a way that is there a data-driven way that the department can make taxpayers believe that their decision is not inconsistent from one matter to the other? So they have a way to reassess things that have been finalized before, and they are opening it. Uh, is there some way that department should assure that they are not being arbitrary in reopening, because that would lead a lot of court cases, right? What's your view, Sunil, Keshav,
Are,
or Gopal?
Mr. Purohit, good evening. Mr. Ganesh Purohit is there. Good evening.
Good evening, sir.
See, so your question is, see, arbitrariness is not one of the factors for reopening. They have to. There are conditions there with the present provision. The reason to believe has to be there. Whether reason to believe has anything to do with the SSC, there are 113 ITRs, Lakhimal, Meval Das, and all. Those are the criteria are there. So if data driven, it's not. It has to, whatever material is there, it has to be has to do something with the SSC. If it is nothing to do with the SSC, just because you are collecting, because all these wherever share transactions are there, and suppose by mistake I have been dealing with 100 scripts in 1 year, one of the script happens to be a penny stock, and there is no actually profit to the extent what they are saying. It is merely a one transaction which I have done, and there also I get implicated because they have got some database. So those kind of cases will not, in the new proposals, will not get affected. They will be, once under the scrutiny assessment, they are verified and they will get closed. I think they will reach a finality. Only thing is, again, whether they will get implicated in the 10 years thing because of the search and seizure and all, that is an issue. Because in the Vivad Se Vishwas scheme also, I am seeing certain issues where they have said the search matters. So such matters, they are going little beyond the scope, saying that all those matters where investigation report is there, they all are, search matters. So we have to see how they are going to look into the 10 years thing. 3 years thing is good, but arbitrariness is not one of the criteria for reopening.
Thank you, sir. We have a question from Mr. Dhingra, Vinod Dhingra. Sir, go ahead and ask your question. Mr. Vinod Dhingra. You can unmute yourself and ask the question. I don't know whether he's being able to unmute himself. Maybe we'll come back to Mr. Dhingra if he can unmute himself and ask the question. I would proceed to ask Keshav something in relation to the bar, as we are giving an acronym to. And Keshav, what do you think? And Sunil, you can also chime in. Is this what we have now devised in the form of a bar? Will we have, let's say, the efficacy that we had always expected from an advanced ruling system? And will you get more confidence from the foreign investor community with the new procedure?
To my mind, it actually defeats the very purpose of giving the tax certainty. The rules are yet to be prescribed, and how it will be done. But possibly Sunil will be in a better position to comment as to the MNC, how those will be viewed, these changes.
So I think there are two things, Dipankar. One is obviously while everybody is still digesting the new proposals. But as I said, two things is unlike I mean, just like AR, when the AR framework was announced, uh, I remember all our non-resident clients, they were extremely happy because all that they wanted was the certainty of doing business in India, and therefore everybody was very excited to actually approach AAR and get the ruling and then take a decision accordingly. But you know how these AARs have been functioning. Today we have cases which are actually pending with AAR for almost close to 4 or 5 years, despite the fact that the legislation specifically mentioned a time limit within which they have to dispose of. So my point is, it will depend upon how the whole framework will be set up and will get executed. Because if it's going to be, functioning like AAR, then obviously it will not serve any purpose whatsoever. Number one. Number two, as Keshav mentioned, if there are the CITs, CCITs who are actually going to give the rulings, then again the concern is that it may go down the path like DRPs, DRP, I mean framework where you will in most of the cases expect a very revenue oriented ruling. So the quick and immediate reaction from the non-resident community is that okay, it is not any longer a kind of an AR which they would understand in the typical sense. It's more like the approach where you actually detect at an early date the potential disputes with the tax office, and obviously you have a speedy redressal of that because you now have an opportunity to go directly to the High Court after the ruling from the bar. So rather than going through the various steps like commissioner, tribunal, etc., you have an entry straight away to the High Court. So it is a process which is a process to detect your disputes at an early date and possibly redress it right from the High Court stage. So there is some kind of a expedition there. So that's the only silver lining we will kind of look at.
Just on a lighter note, if it is like a preventive vaccine, it need to be taken before the.
Yeah.
Right. No, Keshav, you're
May I
correct.
just chip in? You see, uh, intention is correct, but see, appeal they are providing directly to High Court. I remember in the case of Microsoft, which is one of the early matters which had come up before the advance ruling, adoptive advance ruling. In that case, in the subsequent years, the matter landed up before the ITAT. So there were contrarian views were there. And now in such a situation, you go and take an ruling from the High Court. So then what will happen to the tribunal? See, that's what I'm saying. They are giving an uneven treatment to pre-assessment and post-assessment, a pre-return filing stage and post-return filing stage in a different manner. So that will create a more scope for we advocates. We can very well rejoice. So many appeals in the High Court directly. So we are very happy, but that won't as Sunil has said, it will not go down well with the investors because ultimately that is a pre-return stage. So it's not a solution. It's not a well thought out solution.
Right, Mr. Gopal. I think we all here, we all reciprocate the same thoughts. And maybe, we have now run out of time. It's 10 minutes past 5. So unless there are any other questions from the audience, I wanted to ask, of course, if all of you see any missed opportunity, but probably that is for another day, another webinar. I think, we are almost run out of time. So I would take this opportunity to thank each one of you for participating, and my guests, of course, um, and some and both the discussions, and I think the follow-up rejoinders have been very lively. It has helped us to understand these changes better. So I, on behalf of Riverus, thank you, Keshav, Sunil, Mr. Gopal, Mr. Purohit, and all the other audience members who have participated in this webinar. I would now take the opportunity to request audience to stay back for a quick 5 to 7 minutes demo of a judge analytics platform that Riverus has built, which is meant to provide someone a way to find how judges react to different kinds of questions, even when you don't appear before them every day.